Hello again. This is the fifth and final video in my Fall 2015 review series. This video analyzes part 3 of the problem involving the cleaning fairy burglar. If you haven't read the problem, you can find it on our Twin site under course materials. As you know, this part of the problem involves a lab report revealing that the blood found on the sledgehammer was type AB negative. Why does the prosecutor want to introduce the report? AB negative is a rare type of blood, and the defendant Donna happens to have that type. The report therefore provides some evidence that Donna used the hammer to break down the post office door, rather than finding the door already open as she claims. The prosecutor's problem is that an out-of-state FBI lab performed this analysis. It would be difficult to call the lab technician to the stand, so the prosecutor wants to introduce just the report. The report itself has been sworn and notarized. Is it admissible? This lab report is hearsay. It is an out-of-court statement offered for the truth of the matter asserted, that the blood on the sledgehammer was AB negative. Let's consider whether it satisfies any exception to the hearsay rule. An FBI lab created this report, and the FBI is a government agency, so we look first to the exception for public records. That exception, however, is very restrictive with respect to evidence offered against a criminal defendant. This report almost certainly is the result of an investigation, and those results are admissible only against the government in a criminal case. The exception does not include hearsay reports of investigations that are offered against a criminal defendant. Even if we consider the report a public record that is an observation, another part of the public records exception, the report does not qualify for admission against the defendant. The observation section of the public records exception specifically excludes observations by law enforcement personnel when offered in a criminal case. A laboratory operated by the FBI, like the one in this problem, almost certainly includes law enforcement personnel. The public records exception in sum will not admit this lab report. We could also look at the exception for business records, but that exception does not apply to records generated by government agencies. Records from government agencies must satisfy the stricter standards of the public records exception. No other exception even plausibly applies here. The report can't qualify as former testimony because it wasn't made during a trial, hearing, or lawful deposition. It's not admissible as either recorded recollection or the prior statement of a witness because the author is not testifying. Even if we could identify a hearsay exception, introduction of this report almost certainly would violate the Sixth Amendment. The Supreme Court has ruled several times that lab reports are testimonial. As such, they can't be admitted against a criminal defendant without giving the defendant an opportunity to cross-examine the report's author. It is true that a plurality of the Supreme Court suggested in the Williams case that a lab report is testimonial only if it involves a targeted individual. The prosecutor could argue here that Donna was not the only suspect in this crime. Someone else could have broken down the post office door. In fact, if the blood on the sledgehammer had not matched Donna's blood, that result would have supported Donna's story. Perhaps in that sense, Donna was not a targeted individual. On the other hand, she clearly was the prime suspect in the case. She was found at the scene of the crime. In any event, the plurality standard can't help the prosecutor here. Only 4 justices endorsed the targeted individual distinction. The others rejected it. The lab report in this case, meanwhile, was sworn and notarized, so it satisfies Justice Thomas's formality standard. Under that standard, combined with the ones articulated by a majority of the court in other cases, the lab report in this case clearly is testimonial. As noted before, testimonial hearsay is admissible only if the defendant has an opportunity to cross-examine the speaker in court or had a prior opportunity to do so. Donna has had no prior opportunity to confront the lab analyst, so the report will be admissible only if she has a chance to cross-examine the analyst at trial. The prosecutor, therefore, can introduce this report only if the analyst attends the trial and is available for cross-examination. The report on its own cannot be admitted. That's the end of my analysis of this problem. I hope you've enjoyed this mini-series of review problems. Be sure to check the exam forum on our Twen site for ongoing discussion of these videos and other evidence problems.